And good morning, everyone. We're just going to give it another minute or two for people to join, and then we will get started.
Buenos días, solo le vamos a dar un par de minutos a las personas para que se conecten y vamos a empezar.
All right, why don't we get going? Before I jump into today's webinar, I'm going to turn it over first to Erica Perez, who's going to provide some instructions on Spanish interpretation for today.
Buenos días. Antes de empezar, vamos a dar unas instrucciones cómo usar interpretación de idiomas. Good morning, everyone. This is Erika Perez, and I will be providing simultaneous interpretation from English to Spanish and vice versa in the Q&A section. So for English speakers who are not bilingual, you'll see a little globe at the bottom of your screen next to Q&A or raise hand. Click there and make sure to choose English, and you should be all set. If you join in on your cell phone, there's 3 dots on the right side, the bottom, tap there, choose English interpretation, find English, and make sure to press done. And also for guest speakers, please just be mindful that I will be doing live interpretation. So just speak at a regular pace. Thank you. And I'll do this in Spanish. Ok, buenos días. Mi nombre es Erika Pérez y yo voy a estar interpretando simultáneamente del inglés al español y también del español al inglés cuando tengan preguntas en la sección de preguntas. En la parte de abajo de su pantalla hay un globito. Hagan clic ahí y escojan español. Si está usando su celular, hay 3 puntitos en la parte derecha, en la parte de abajo, presionen ahí, escojan interpretación de idiomas y luego escojan español y asegúrense de presionar finalizado. Y solo les recordaba que no hablen tan rápido, solo un ritmo regular. Thank you, all set.
Great. Thank you, Erica, and thank you to everyone for joining us today on this webinar. As many of you know, this is the first of a 3-part webinar series that Bernstein Scher is co-hosting with our great support from Cooperative Maine Business Alliance, CDI, and CFNE. We will have additional sessions coming up on next Wednesday, October 18th. As well as a final session on October 25th. For those that don't know me, my name is Adam Prescott. I'm an attorney at Bernstein Scher in Portland, Maine. Joined here today by 2 great panelists for our first session on human resources best practices. First panelist is my colleague here at Bernstein Scher, Tara Walker, who is a shareholder in our labor and employment practice group. And Tara's joined today by John Crane, who's the general manager of the Portland Food Co-op right here in Portland, Maine. So with that, let me turn it over to Tara to walk us through today's agenda and get started.
Great, thanks, Adam. Hi, everyone. Thanks for joining us. I know we did the same presentation last year with slightly different topics in mind, but we're going to follow a similar format today because I think we thought it was just very helpful. We are going to start out with just a brief introduction, which Adam has already done, and then cover essentially the employment laws you need to know. I'm going to focus on if I didn't have a human resources person or even a dedicated human resources department, and I came into this knowing absolutely nothing, what would I want to take away from today's presentation? Some specific action items, things they can be doing right now to make sure that I have in place the policies that are most protective, and the practices that I'm supposed to be following, what's very likely to apply to me as an employer. Part 3 we're going to go into is some hypothetical questions. This is the part we found really most entertaining, and it fostered some really excellent Q&A sessions last year. We wanted to revisit that this year. So before this presentation, John and I worked on some questions that we thought were the most realistic. Of course, I would never give away attorney-client information in this presentation, but I will tell you that these are quite realistic types of questions that we get every day, and that you may be likely to encounter. So we'll go through some scenarios, and usually what we find is that those start to engender more questions. People start to think about their own environments and questions that they may have. That is absolutely encouraged. We have a pretty, we have a cozy group here. We've got 31 people attending right now. I can see on the participant list. So just pop your questions at any time into the Q&A. We've left plenty of time for that at the end of the presentation. So I think that's really where you get the most use out of today's presentation, and the most dynamic discussion can occur. So with that, let's get into it. All right, so I have provided a list here of employment laws that you need to know. And this is a really scary looking list if you were to just look at it on first blush. It's a long list. The area, when you become an employer and you start employing people, what laws do you trigger? What laws do you not trigger? And what the heck do they require? It's a long and convoluted list. It's a heavily regulated environment, but we're going to start by just giving you some real core takeaways. You don't need to worry about every single one of these right now. There are some best practices that you can follow that will get you started toward compliance. And then I'll wrap up this section by giving you sort of a general overview on compliance best practices if you want to go the next level. So the first, I would call this category of laws that you need to know, are wage and hour laws. Wage and hour laws govern how people have to get paid, often when they need to get paid, and of course, the million-dollar question, how much do they need to get paid? Wage and hour laws, the classic federal law that most often gets used or applied is the Federal Fair Labor Standards Act. So this you will recognize from the bullets in this slide as being the statute that sets out requirements for the minimum wage. Federally, we're talking about $7.25 an hour, and overtime laws. So again, federally, we're talking about 1.5 times the employee's regular rate of pay for all hours worked over 40 in a week. It's generally just the overtime laws. Those are the two core requirements. And you can see state laws often enact, states and localities often enact laws that mirror the Federal Fair Labor Standards Act, but provide more protection for the workers in those jurisdictions. So it depends on where you're located. For example, in New York, you have a state minimum wage at $14.20 an hour. But just to make it even more confusing, we're going to have a higher minimum wage in New York City at $15 an hour. So you need to make sure that you're checking not only the state law in your area, and these can be quick Google searches, but also if you're opening a new location in a new municipality, for example, what's the minimum wage requirements there? Similarly, with overtime, you have a lot of state laws like Maine, where I happen to be located, that mirror the federal law requirement for overtime, paying time and a half for 40 hours in a week. But then you have many state laws that differ markedly from those. So California is a great classic example. It requires time and a half for more than 8 hours worked in a single day, or 6 consecutive days in a week. And then they go to double time, we call it. So it's not just 1.5 times your regular rate, but 2 times for 12 hours in a day, or 8 hours in the 7th consecutive day. So a lot of days in a row. You need to know what those obligations are. The best resource for you to find this information is your state Department of Labor website. You will have posting requirements for what the minimum wage is and where to where to include this information so that your employees can find it. So go on your state DOL's website, download those posters. That will give you a good head start on the information that you need. I want to focus on the things that are a bit one level above probably the minimum wage and overtime, which I think most people already know about. And that's exemptions. And this is where I see a lot of people start to trip up and run into compliance issues. When we talk about wage and hour laws, these are what I call pretty high risk compliance issues. If you get these wrong, the potential for back wages, penalties, and attorney fees is quite high. So you want to make sure that you're following the laws, especially as they can get convoluted around, we're going to talk about exemptions in a moment, and tip pooling can be another area that is a common pitfall, prompt payment, and then making sure you're paying for all hours worked. So we'll just hit those major, I would call those traps for the unwary, things that I see people typically miss. Because there's a private right of action, employees can actually bring a case against an employer if they are paid incorrectly or they're not paid according to these laws. There's a whole cottage industry of attorneys out there that do enforce these laws. It's well worth your time, effort, and resources to make sure that you are understanding your obligations and that you're in compliance with these. So when we talk about exemptions, the common myth that I hear is if you're paid a salary, you're not eligible for overtime. And that is incorrect. Well, I should say it's not necessarily incorrect, it's half correct. You are required to be paid a salary in order to not be eligible for overtime, but that is not sufficient. There are specific duties tests, and you can see this on my slide here. Administrative, professional, and executive exemptions are the most common. Those are specific jobs that are described in the statute. They have to perform certain duties. So an administrative professional is somebody who works inside the business, really on the operations end. This is somebody who does human resources functions often. They can set policies for the organization. This also might include any finance people that you employ. Those are the types of jobs that might be qualified for the administrative exemption. They have to have discretion and independent judgment. These are not low-level employees. Professional exemptions are those, there's a couple of types: creative professionals like artists, musicians, and then what they call learned professionals. So those would be degree earning people. So like attorneys, for example, architects, engineers, those are people that commonly would qualify for the professional exemption. Executive exemptions aren't just those high level employees. We're talking about somebody whose regular duty is to supervise 2 or more employees. So what I see most commonly missed is you've got the salary piece, which is required, but you don't have the duties test. So nobody's looked at what is the job that the individual is performing. And if you aren't paying overtime because you assume that someone's salaried, they could then come and request all those back wages. Some state and local laws have prompt payment requirements. Maine is one. If you're not paying within a certain time frame of the time when the money is earned, then there's a violation of the prompt payment statute, and you could be hit with fines for that. Often what I see, this is both federal and state, what I see is people who are not correctly calculating the amount of hours that need to go into what's paid for, so what's working time, and then what gets counted for overtime hours. So for example, what I often see is travel time. This one can be more complicated than it sounds at first blush. So travel time does not include commuting. to and from a regular work location, but we live in a hybrid work environment. For many of you, you may have employees who don't report regularly to one, storefront or office location. So when does travel time become compensable? That's something you may want to carefully look at. Employees who are traveling for conferences, for example, attending trainings. Those are very common mistakes that I see employers make by not paying for those hours, even though they do technically fall within the definition of hours worked, depending on the purpose for the travel and when it occurs.
I was going to say, Tara, I'm glad you brought that up, because I think for co-ops, that's a really common one, or for a lot of smaller businesses, having hourly employees or staff people that you are sending to a conference or sending for something, and remembering that it's not just their time while they're there at the conference. You need to take into effect their travel time as well and figure that in. And I know it probably varies by state, but I know in Maine, it's almost from doorstep to doorstep is almost when you have to pay them.
Yeah, there are complicated overlaying rules, and this is a common question that I get. Wait a minute, I'm paying for the time they're sitting on the airplane. If it crosses over the regular workday, you are. Yep. So that's a good trap for the unwary. The last one I didn't put on the slide, but I do want to mention, for those of you who have employees who get tips. I mean, tips has exploded. Both, I think, culturally, now we're seeing employees receiving tips who never, I think, previously had received tips. And also, tips have just gotten much higher since the pandemic. And I think what you want to be very careful of, what you decide is, do you have a tip policy, right? Sometimes, in some occasions, you can pay employees less than the minimum wage, what we talked about at the beginning, if they make up the difference in tips. So we call that the tip credit. In order to take the tip credit, you have to have very specific policies and notice provided to your employees. And then who's allowed to share those tips, or who's required to share those tips? Managers cannot share in the tip pool. And there's been some very, very recent changes on the federal level, and in the state, even more recent on the state of Maine level, for employees who work in a traditional back of house environment. So if in a restaurant, you think of these individuals like cooks, dishwashers, bus people, those will often were often excluded from the tip pool in years past, but are now allowed to participate in a tip pool. So you want to make sure that you're following the appropriate sharing requirements as well. That's wage and hour in a nutshell. The next big category of laws that I would have you consider are the equal employment opportunity, anti-discrimination, anti-harassment laws. You should be taking a look at your state and local laws. I've provided common ones here, a list of protected classes. These are different in every state. And again, just because we happen to be in Maine, and I saw a number of you have registered who are attending from Maine, I'll give you an example. These are also very often changing. In 2022, the familial status protective class was added in Maine, and that is defined, I think it makes sense if you think about it with respect to where it came from in the law, which was housing discrimination. It's defined as someone who has children, minor children in the home, in a custodial relationship. It doesn't have to be parent-child. You don't have to approve, parental rights and responsibilities under any official state law. But if they're, guardians, or they have regular care of a child that lives with them in the home, that's one form. The other is if you have an adult dependent, even if they don't live with you. So those two groups of individuals are now protected in Maine under the familial status category that we see here. So be aware that these are often always changing. We recently heard, many of you probably heard on the news, quite a newsworthy discussion of California considering adding caste as a protective class. This is something that I think is common in South Asian populations, and they wanted to include that as part of their harassment, discrimination laws as a protected category. The reason you need to know what these are, you need to be updating your policies. You need to be including these and understanding which categories of people are protected, so that when you have to make employment decisions, if you have to engage in a termination, for example, you're aware, and at least to some degree, what the risks are with that particular individual. I also commonly recommend to everyone employment practices liability insurance. I can sing it from the rooftops, I think. Employment practices liability insurance, EPLI. I don't know. Do you guys have this, John? Do you know? Or
Absolutely.
Yeah.
I couldn't imagine, especially in this day and age, with so much that people need to know about employment, not having that coverage, should you even just inadvertently not be aware of something. It really it allows you to sleep at night, knowing that, oh, maybe I didn't read every statute, but I know I'm covered.
You're covered. Yeah, have insurance. So any harassment or discrimination claims may be covered by this. Wage and hour issues, what we talked about in the last slide, are not covered under EPLI, but this is still worth getting. They will pay for your attorney fees for an attorney to represent you. And then you'll have some deductible, but up to a certain policy limit, whatever you set your policy limit at, they will cover. And that is huge protection. I've represented people who have it and people who don't in litigation, and it is a drastically different picture for those who have it. I think if you have more than 2 employees, even if you have more than 1 employee, you should be getting this.
Yeah, and the cost of it oftentimes is balanced by savings on either business or compensation insurances. And so it works out in the end regardless.
I will say, for those of you who are attending from Maine, we have recently had a couple of big changes. And so if you had, it's been a hot minute since you looked at your EPLI coverages, I would advise you to get in contact with your broker, because 2 things have happened. Number one, we had 2 cases in 2021 and 2022 that considered whether, let's say you have an employee who brings a discrimination claim for disability. That is protected under the State of Maine Human Rights Act, as well as the Americans with Disabilities Act. This probably also goes for Massachusetts, New Hampshire, and Puerto Rico as well, because you're all within the First Circuit. The court in the First Circuit has considered whether to separate those 2. And many of you have probably seen there are caps in the statute on what an employee can recover if they prove discrimination. Depends on how many employees you have. It used to be a maximum of $500,000 if you have 500 plus employees. The max you could recover of these major heads of damage, major damages. Now, what the courts have said is that we can consider those separately. And in fact, with those caps, we're going to stack them up. So if you have a, let's say, $200,000 cap under state law and a $200,000 cap under federal law, it doesn't matter that it's essentially the exact same claim. We're going to allow the employee to recover for both. So they could get up to $400,000 for that one claim that previously only used to be $200,000. The other thing that happened in Maine is we had a big statutory increase. So those caps shifted significantly higher. And that was just this year in 2023. So I would look at your policy limits and ask about increasing those. I think that's probably good advice for those of you who are attending from other states as well. If it's been a while since you've looked at those caps, your broker will have a good sense of what an appropriate policy limit is based on your number of employees, and whether it's time to update those. All right, so what are the real 4 essential things you need to have around these protected classes, harassment, discrimination, retaliation. I am a litigator. I represent people in court all day long. That is primarily what I do. And these are my favorite exhibits to use. So just know that these tools are here for your protection. They're also here to benefit your employees. So you absolutely should have an equal opportunity policy. This often shows up if you post a new job, you say, the Portland Food Co-op is an equal opportunity employer, for example. That's great. I think we can probably build that out even in your job advertisements to be a bit more robust. But this policy lives in your employee handbook or manual. And it says we do provide equal opportunity in all aspects of employment. So that's important to cover as well. That includes hiring, training, performance evaluation, job duties, termination. We don't discriminate on the basis of those protected classes. And I like to list those right out into your policy. Prohibiting harassment. Absolutely need to have those. And honestly, I'd go a step further and have a separate policy for sexual harassment. And I feel like I keep harping on Maine, so I'm going to keep picking on you. You're required to have that in many states, including Maine, a separate sexual harassment policy. It is good business practice to have that anyway. So you have a policy that defines what sexual harassment is. It tells your employees if they experience it, where can they go to? One really common mistake I see is in these harassment and discrimination policies. If you're having trouble with your coworker, try to work it out on your own. That language should be taken out of those policies. I have seen that backfire many times where an employee said, well, I didn't feel like I could report this. Now, of course, we're in a lawsuit. I didn't feel like I could report this because you were going to send me back to confront my harasser, for example, if that's what the allegations are. And so take that language right out of your policies on harassment and discrimination, the language that would have them, try to work the differences out. Instead, you should have, here's where you report your concerns to. That should be, right? John as GM, and then a backup person. If you don't want to go to John, you want to go to someone else, here's the, secondary reporting party that you can go to. And those people have been trained on what to do when an employee reports harassment. Now, harassment is the specific legal term that refers to interfering with someone's work, being offensive to them. I'm using sort of lay people terms. There's lots of legal technical jargon, but it essentially means interfering with someone's ability to do their job based on one of those protected classes. It often shows up as making comments oriented towards that person's protected class. A really common one I'm seeing right now is misgendering. Calling people by pronouns that they don't identify with, that are not their pronouns. And we know that, that can happen accidentally from time to time. What I'm seeing a lot of right now, maybe you are too, John, I'm not sure, is how many times is something an accident before it's not an accident anymore?
Yep.
So those kinds of claims can be harassment.
I'm good with it. Is it common, I know in Maine it is, that beyond just having a policy on sexual harassment or harassment, that workplaces should also do trainings on this? And that there's a training requirement that I don't think many people are aware of coming out of the gate.
Yeah, that's absolutely right. Those two are both, I probably should have drafted this slide a little bit differently because they did talk about 4 essential policies, but you're right, that training is another piece of this. And I like that to encompass everything. You're required to have sexual harassment training, but it should cover general discrimination and harassment as well. So when I talk about general, it's based on any protected class.
Yeah. We've developed 2 programs over the years, one for all staff and then another specifically for managers, which goes a little more in depth of what do you say when a claim for harassment comes to you or you witness something? And it's a little more on how guiding that process, but also one to everyone, just really letting them know that harassment is prohibited and here's what you do if you encounter it, and modeling what it looks like, so people are aware.
Right. Absolutely. Now these show up often in litigation when I end up there, right? The question that's going to be, the first question the attorney who's representing the employee is going to ask is, did you have a policy? Did you tell employees that this was prohibited and that you would take action? Because the implication is, if you don't have that language, you don't have that training, you were probably falling down on the job in enforcing the protections that were supposed to be there for employees to prohibit this kind of conduct. So really, that also includes it sounds like paperwork, and I feel like Roz from Monsters Inc., you forgot to file your paperwork. But you have rosters of people who attended that training. That is worth its weight in gold to me as a litigator when we get down the road. So do those trainings, have those policies, get acknowledgments from your employees that they received the handbook with all these policies in there and they attended your trainings. That's Exhibit A for me. Mm-hmm. Complaint procedures is the last one on this list. We talked about that briefly. What's the avenue for this? What's our investigation process going to look like? We should have one established where an employee's report of these kinds of allegations follow a process, right? So we could either bring in an external investigator, we could do it ourselves, and we will interview the relevant parties and make a decision about what occurred. The last, I think, kind of pitfall and law you need to know about, and this is the one that I just see the most common, and I think is showing up the most common. It's not just in the pandemic or following the pandemic. Of course, we had a lot of requests for accommodations. It is everywhere now. And that is accommodations for individuals with disabilities. Right now, what I am seeing most often is mental health. For some reason, I think it may be in our country at the moment, or following what we've all been sort of going through as a collective over the past several years, we've had a shortage maybe of mental health providers. I see a lot more requests for accommodation based on mental health issues, requests for leave for mental health issues. And this is really important. So federal law, Americans with Disabilities Act applies to this if you have more than 15 employees. Under state law, almost always, in most states, it's one or more employee that these disability requirements. I can't speak to every state, but most of the states that I'm familiar with, it's one or more employee, these obligations apply to you. So that means, when somebody comes to you, they don't have to use the magic language, I need an accommodation. They can just say, you know what, I'm having a difficult time at work. I need to take some time away. My therapist said that I need this break. And that should be enough to trigger in your mind, okay, this looks like maybe it's an accommodation for a mental health condition. And if you aren't in a position to grant that, you need to talk with legal counsel.
I can't stress enough how much I like, without getting into details with what I do with my regular job, but things are how much of an issue this is and how important it is in your workplace. Before you speak, think about, are we discussing a possible claim for disability here? And being very careful how you approach this. Probably the largest lesson I've learned over the last 10 years, but especially the last 3 or 4 years, I think people are recognizing more mental health issues, being diagnosed more often, or feeling free to bring these to share these in the work environment. So I think it's very important. Consult your counsel, understand your obligations, and what your obligations are in terms of accommodation. Gone are the days when someone could just come to work and say, oh, I'm not feeling well. And you're just like, oh, buck up. We all had a rough day. It's just, and for some of a certain age, we grew up in that type of work environment, and you cannot bring that frame of mind to the workplace today. You really have to be aware of where people are coming from and make sure that you're being accommodating under the law.
Which also includes, again, I know I sound like a broken record, having the policy outlining the process to provide accommodations. Who's the person we go to, and what's our process? So that will often look like we may ask relevant follow-up questions from your provider and determine whether we can grant reasonable accommodations, as long as it doesn't produce an undue hardship or a direct threat to the safety of the employee or others. All right, so let's start on our, since we're right on this topic anyway, let's start on our hypotheticals. We're going to focus in on disability issues. John, do you want to start by reading this one out?
Sure, and this was actually, I think, fun for us to work on, and disclaimer, we are not talking about any specific person that we know, but we have both had many conversations over the years, and there seem to be some common themes that arrive. And so this one I can very much relate to. Employees with disabilities. We have a staff person who is called out more than our attendance policy allows. During my conversation with them, they stated they have been having mental health issues. Since they mentioned mental health, what illegal obligation should I be aware of? What if the employee instead says that I needed a mental health day?
This is the classic.
I feel like anyone involved in HR or management is having this exact conversation on a regular basis.
Yep. So I think my takeaway on this and my response would be, they've stated they've been having mental health issues. Oftentimes, an employee may volunteer information to you that you didn't necessarily ask for. I have, anxiety disorder. I have PTSD, and I just have been really triggered by working at the cashier desk lately, and I need to take some time off. So it is not up to you to decide right in that moment. There's a process that you should follow. And that first step of that process is often gathering more information. So I typically provide my clients with a certification form, and that's only if the need is not obvious. So you can't ask questions if the need for disability is obvious. For example, you have an employee who comes in a wheelchair. You should not be asking them questions about why they're in a wheelchair or if they truly need this. The questionnaire is designed to get at, what is there an eligibility for an accommodation? So that's information that's relevant and necessary for our process on the nature of the condition that the employee has. It can include what restrictions and limitations they may have as a result of that condition. Depending on your state law, PTSD may be a disability. The federal definition is it limiting one or more major life activities. And often with mental health issues, we're seeing things like people unable to speak, people unable to communicate effectively. They're unable to, sometimes, depending on your state as well, work may be a major life activity. That differs from state to state. So that's, if you're in a position where you need to deny the accommodation request based on a judgment like that, should be done with the advice of counsel in your local area. And then, you go through your process to determine whether you can give that. And when I'm thinking about that with my clients, I'm thinking about precedent. Someone has requested some time off. If they're not eligible for family medical leave time, but we have other employees who are, oftentimes the court would read that as being a reasonable amount of leave, even though they're not quite eligible. They haven't been employed here for 12 months yet, for example. So specific leave policies that you offer to other employees, those are going to generally be seen as reasonable accommodations. Things that get a little closer to the gray area, the tough calls for us lawyers, are unforeseen pretty regular absences with absolutely no ability to provide notice in advance, unexpected call-outs. Those are ones that are seen as less reasonable. And then the very clear unreasonable is indefinite leave. I don't know when I can come back. That's not a reasonable accommodation you have to account for. So you can say, you know, we don't have to provide that to you. So you have to go through that whole process. Sorry, go ahead, John.
Okay. Is it still appropriate for employers to ask for medical authorization, a doctor's note, or something like that for requests for accommodation?
Mm-hmm. Yeah, typically it is. So in the certification requirement, or so if you're going to provide a certification to the employee, I have a section in there that's directed to their provider that says, can you tell me what the restrictions and limitations are of your patient? So it has to be medically, right? It has to be business necessity, and it has to also be not obvious that the employee's disability, you know, if you can visibly see that the employee is unable to perform certain functions just based on their condition, and it's not open or obvious, that's when you can actually direct questions to their provider, and that's where you get often the most helpful information.
It gives you peace of mind, or just knowing that you now have sort of clear guidance, or saying this person should not work more than 6 hours at a time, or should not stand more than this, or lift more than this. Or I've heard of ones that say this person is going to need up to 3 to 4 days per month off because of a condition. Letting folks know, just you will not get a diagnosis or any detailed information through these recommendations, nor should you, but just the guidance that you need to know to provide the accommodation they're recommending.
Yeah, that's great. And then mental health day is a question I'm getting a lot. I think colloquially what we're talking about is, you know, I need a day off because I'm stressed, and this is to benefit my mental health, but is not necessarily I'm requesting leave because I have a mental health condition. That's, I think, a reasonable interpretation.
I know, just from a boots on the ground HR perspective, the way I often approach those is, I understand the world is stressful and we all need those once in a while. If possible, I would appreciate you scheduling your mental health days so that we can plan appropriately around that, instead of you just calling us at 7 o'clock in the morning. If you can't, we can talk, but giving people that mindset that we're open to mental health days. We're not saying, no, you can't do it, but boy, could you give us a day or two's notice just so we could find your replacement, or not have to scramble. And I find that just creates a more cooperative work environment when people know we'll work with you on this, but please meet us halfway.
Yeah, that's great. All right, I'll read this one to you. I have a staff person who came to work visibly intoxicated. She knocked over several shelves, and we had to have someone drive her home. She's entered a residential treatment program, but we recently learned from her sister that she left the program early and is not cooperating with treatment plans. Can I require her to complete the program before, this is a tough one, before returning to work? And by the way, I have more than 50 employees. Do I have to provide family and medical leave? We've got one more question. I have obligations under the ADA. Is alcoholism or substance use disorder a disability? I can answer that one.
I was going to say that would be because my very first question I was going to interject with, is there even an obligation to keep this person employed if they came to work visibly intoxicated, just regardless of anything else?
So I will start with the third question, because this is the one I think is counterintuitive for most people. So, alcoholism and substance use disorder are defined as disabilities under the Americans with Disabilities Act, but they're in a special section all their own that says you do not need to accommodate them. So you cannot fire this person. You really seem to have lost control. You've got a problem with alcohol. We can't have you around here. That would be an illegal termination, because it's discriminating on the basis of alcoholism. But do you have to provide accommodations, for example, for an employee who is experiencing alcoholism? Here, what we're talking about is leave, right? she's requested leave to attend a treatment program, and now we've learned she's not cooperating. Family and medical leave also has really specific requirements in this example. You are not required to provide leave for an employee who has even alcoholism and substance use disorder may meet the definition of a serious health condition. This is something somebody can take leave for. But if they're not actively engaged in a program, that's not leave you're obligated to provide. You don't have to provide leave while someone is using substances. So that would make them ineligible for family and medical leave. Can you require the full program? That's really up to the employee and her doctor, in my opinion. I think what you can provide is clearance from her provider to return to work. I have worked on these in really hairy situations where an employee safety is at issue and an employee wants to return to work. I have worked with some of my clients to draft specific correspondence to their medical provider that say, let's say we do receive a clearance saying this person is fit for duty. We just want to notify you, this is what happened the last time she was at work. Do you see any restrictions or limitations? Do you see any issues with her returning to work safely? I think that might be the most that you can do in this situation. And then what about the fact that she came and knocked over shelves and violated what I would expect you to have, which is an alcohol use policy or a drug and alcohol policy? You can absolutely discipline for that. You do not have to accommodate violations of those policies just because alcoholism may be a disability or may be a serious health condition under FMLA. All right.
Okay, so employees with disabilities. A staff person told me they cannot perform all aspects of their job because of chronic pain. What are my legal obligations? What should I do first? What can I ask for? And the million-dollar question, how do I know if an accommodation is reasonable?
This is a great one because it's just vague enough that we can play with the facts a little bit. So all aspects of their job, the really key question is, are any of those aspects essential functions? How do we know if a function is an essential function? The definition, I love when laws oftentimes have these recursive definitions. They refer to themselves when they define the term you're looking to define. So an essential function is a key one that is not ancillary to the job. It's not very helpful for you. But I'll tell you what a court will do. The court will look at your job description that you had in place before the employee requested this. That is the only kind of evidence they will consider and give you deference on. Once you change that, or if you didn't have a job description in place, the court will consider it, but it's always viewed with this eye of skepticism. Like maybe you're just saying this because it's inconvenient for you. But if you have the job description that sets out the functions before the request is made, it's a really good reason to have written job descriptions for all your positions. You get deference for that. It's listed on there as an essential function, or as you know, even just in those bullet list of duties that employees perform. That is probably, you know, unless it's a really minor amount of time that the employee is engaged in that activity, is probably going to be seen as an essential function. And you do not have to remove essential functions as a reasonable accommodation, but there may be. This is where I like to look at the Job Accommodation Network, JAN. That is a website that provides a whole host of options that you may not know are out there for employees with specific types of limitations to help them perform the essential function. So this might be assistive devices. It might be, and it depends, right? A chronic pain, I need to sit down at the cashier desk, or I need to take regular breaks at certain periods of time. This is when an employee's physician is most often helpful in providing the information you're looking for. So your legal obligations first are to go to that person, get the clarity that you need. Usually that looks like a form that they take to their doctor, and it says, what are the restrictions and limitations? That would be the first step.
I think this really speaks to the importance of, and I've seen so many job descriptions that sort of spell out the duties of the job, but don't get into essential functions. I've done a lot of work around this, thinking about, do you need to be able to bend, to stoop, to twist? Do you need to have good finger dexterity? Do you need to be able to focus up close and at a distance? Do you need to be able to lift 10 pounds over your head? Especially for manual labor positions, but even office positions, whereas you need to be able to sit in a chair for extended periods of time, really thinking those through about what's essential and writing it down, because so many people don't do that.
Absolutely. There are great websites out there that also have lists of these when you think about them, what you should include in your job descriptions. Right now, I'm recommending to everyone, if you have a hybrid or a partially remote work environment, even if you don't, I'm including as written essential functions, the ability to work in an in-person environment. That's required. And you would be surprised how people may challenge, working at the Portland Food Co-op probably can't be done remotely, but they will challenge it if they can.
We added one during the pandemic specific to, let's be able to manage the frustrations of working with the general public for extended periods of time. Letting really people know, if this is a public-facing, public interaction job, that is not everybody's cup of tea, and really sort of letting people know that, yeah, this is not a backroom office position, or what the level of people interaction is. And probably also on the other end, if this is a work from home job, must be able to prioritize yourself and work without collaboration or coworkers.
Before we move to the next slide, I just want to give one final thought. What accommodations are reasonable or unreasonable as a matter of law, whether something is an undue hardship? This has years and years of case law behind it. There's not a list in the statute that says these are reasonable, these are not. So really, again, I just reiterate, if you're in a position to deny someone's request, you should be doing that with the advice of counsel, because it is a complicated analysis. All right. I'll read this first harassment. I feel like I'm giving you all the ones that I wrote, and you will make these more tricky.
That's all right.
So we're getting into harassment and discrimination now. A staff person came to me after hours and told me another staff person is sexually harassing them. This staff person, the reporting person, Tina, has shared that the other staff person, Stephanie, keeps coming up behind her. Stephanie stands uncomfortably close, really hovering and watching her do her work. And they were out for drinks with two other colleagues when Stephanie put her hand on Tina's legs and on her leg and started moving her hand up Tina's thigh. Now Stephanie has texted Tina, which Tina shows me, saying, "Great time the other night. Maybe we'll get stuck late working together." And let's add just one more detail to this. She puts a winky face after that text message. Is this even sexual harassment? So what do you need to know? What are your first steps? Do you need to speak with these other two staff members?
I think I will throw in there, is it important to know whether, so Tina has stated yet that she is not interested in these engagements, or whether she needs assistance doing that if she's not even felt comfortable expressing that?
Yeah, that could be a relevant layer to this. If that's happened and it's being ignored, that escalates the level of seriousness. I think to me, this seems like a fairly common sexual harassment complaint that I'm seeing. It's not necessarily, I think we've started in the Me Too movement to move away from the classic scenarios where it's really obvious, and into a little bit more nuanced, right? This one, I think the hand up the leg is not nuanced at all. But what happens if it's outside of work? They're out for drinks, and this has nothing to do with them being at work. I'll give the answer to that one. Unless you want to, John, doesn't matter.
You know what? I'm going to let you go ahead on that one, because I almost would actually be asking before, because of the out of work, but still carrying it over into the workplace issue of it.
Exactly. Exactly. Doesn't matter that it occurred outside of work. This is the one that I think people often, again, that's why I threw that in there, because I think it's one that people often mess up. What happens that even though it's occurring totally outside of work, and I've had clients whose sexual harassment complaints have dealt with roommates who are, really truly making allegations at work about things that happened in their capacity as roommates. But it carries over into the work environment. And so as you are their employer and you have an obligation to protect your employees from harassment, it does not matter that it occurred outside of work and away from the work context. So my first step in this would be to sit down with Tina and really go through my investigative process. Who was there? What happened? When did this occur? Did anyone else see? Do you have emails or text messages you can show me that you're referring to? This is the beginning of an investigation process. And then after speaking with Tina, I do think it's a great idea to go and speak to the other two colleagues. Did you see this occur? Did Stephanie have her hand on Tina's leg? Were they acting flirtatious? Did you get the understanding or impression that this was some sort of sexual advance or romantic advance by Stephanie? Does not matter. I think we've probably all understood that it's between two women, or between a man and a woman, or between two men. None of that matters. We've got female sounding names here. So that would all still go through your normal sexual harassment investigation process. Ultimately, finally, after speaking with everyone else, I would sit down with Stephanie and I would say, I've gotten this complaint. First thing I need to tell you is we prohibit retaliation for anybody who makes a complaint under our policies. But I need to ask you some questions. I haven't made a decision. Here's what's being alleged. Walk Stephanie through the facts and get her side of the story. Okay, I'm going to take that under consideration and make a decision after you speak to her about whether discipline is warranted, whether this was sexual harassment. Keep in mind, the definition of sexual harassment is unwelcome conduct from the perspective of Tina. And she doesn't necessarily have to do anything affirmative to indicate that it's unwelcome, particularly when you have two employees who are in a power imbalance. You have a supervisor and another employee, or you have somebody who's, higher on the reporting structure than the reporting employee. You might not have any indication that, or the person who's alleged to have engaged in harassment might not have any indication that the person thought it was unwelcome. That doesn't matter. We've all been in situations where it's deeply uncomfortable and you may just shrug or giggle a little bit. You still have to go through the process and investigate that as sexual harassment, because ultimately, if it's unwelcome conduct that interfered reasonably with Tina's work environment, that would meet the definition.
I think that's especially true for people with supervisory control over other people. So there is an assumption that people know better than that, and that there is a power relationship that plays into harassment, and being especially diligent in not only noticing it, but providing the appropriate intervention up to and including termination if you need to.
Yeah, exactly. Great advice. All right, I'm just mindful of the time. It's now 1 minute till. This is our last one. So what I'd like to do just real quick is answer a couple of quick questions. And then if anybody wants to stay on, we'll do the last one if you're okay with that, John.
Yeah, I'm fine.
If If training is voluntary or optional, one person requested, is that required to be paid? Yeah, as long as it's training that's relevant for work and to perform the work. The standard test is whether you're suffering or permitting the employee to work. This is old statutory language. Doesn't matter that the training is voluntary. Still have to pay for it if they attend. And it's really for work. So it might be DEI trainings. It might be, trainings on certain processes that you need the employee to perform to do their job better. All of those would need to be paid. Maine is an at-will state. Does that make a difference in the accusation of wrongful termination? Potentially. I will say this, almost everybody fits into a protected class. So even though we say we're at will, you will always, if they're alleging, the employee is alleging they've been terminated for based on their membership in a protected class, you'll have to answer the reason why. So even though on paper we say we're allowed to terminate for any reason that's not discriminatory, or otherwise unlawful, you will very often be required in the course of litigation or if challenged to defend why you did the termination. So just think about that before engaging in termination. Is it allowed to do sexual harassment or workplace safety annually? In Maine, yes. Other states, not necessarily. It's a good business practice, but it will depend on your state law. Last question here. Thanks for this topic, very practical. I think I missed when this popped up, but the 7 principles of co-ops. For 2 principles, education, training, and principle 7, concern for communities. Co-ops and businesses have to and should follow these rules for compliance reasons, but from a mission perspective, this is a great point from Chris. Should be doing this automatically because we're all here and need to live up to the 7 principles. That's a great bit of feedback.
Thank you. Thank you, Chris, for bringing that in, because that really is for folks who might be like, oh, all of these legal this is all about being a good employer, being good to our workers, to our members, whatever your cooperative arrangement is, your contractors, and setting a very high bar for fair and equitable treatment and making sure that that is first foot forward in everything you do. You're right. I think we as cooperatives have an obligation to not only meet but exceed in all of these areas because it's the right thing to do. And it's sometimes can be a little easy. And I have been involved in cooperatives where like, we're all just members here. We're all friends. We're all co-op people. We don't need to get into the nitty gritty of, and yes, you do. Because this is all about not only treating people well and ethically, but also protecting our organization from making very serious missteps, which could really put everything in jeopardy.
Very well said. Absolutely. Let's just run through this last one. I know you've all got lunch to get to and other meetings. So a staff person who is Black has called to tell me they believe they're being discriminated against by one of their white colleagues. This employee, Romy, who's reporting to me, has stated that Michelle, another staff person, the white staff person, who works with her but is not her supervisor, has been comparing Romy to the previous person that was in Romy's role, focusing a lot on what Michelle can teach Romy, complimenting her on being articulate. Romy tells me these are clearly instances of racial aggression and antagonism, and she is being subjected to a hostile work environment. This is probably a trick question that I can happy to answer, but what the heck is a hostile work environment? And what should I do? How do I respond to Romy's concerns?
Yeah, I think a hostile work environment, the definition I think of is that you have changed the nature of the work environment so that someone does not feel comfortable there. And I'm sure we have some very knowledgeable people in our room here, but the word articulate is never a compliment in really any, maybe when speaking to a 4-year-old, but for any grown-up, it is saying that the expectation that you, for some reason, should not be as articulate as you are. And it's just never a compliment in any way.
Yeah, that's a loaded term and a concerning one. That's certainly when Romy's, again, right? Even with sexual harassment, we talked about this being the perception of the person who is subjected to this conduct. This is Romy's perception. Even if Michelle doesn't know how loaded that term is, and it may referred to as backhanded compliments. It may sound at first blush or on its face like, oh, I was trying to be nice. The implication being, I didn't expect you to sound articulate. I didn't expect this. It can be very damaging for people. I think your response to Romy is just exactly what your response to Tina was. Sit down, let's go through our investigation process. I'm going to ask lots of detailed questions about what occurred, when it occurred, when did Michelle make these statements? What was the context? Was anyone else present? And then do the same thing, right? You're completing your investigation, talk to Michelle. What was Michelle's side of the story? And is discipline appropriate? Hostile work environment is a high legal bar. It does. You described it very well for not using any of the esoteric legalese, John. Altering terms and conditions of employment. You're right. It's changing the job. You have made it very difficult for me in the conduct that you're engaging in. Even though Romy has referred to this as discrimination, ultimately what she's talking about is harassing conduct. And if there's not an adverse employment action, when this becomes a legal concern is when it rises to the level of a hostile work environment. So that's why we talk about that term. I think it gets overused by a lot of people. But it is a bit of a high bar. Does that mean if it doesn't meet this bar that you shouldn't respond and maybe even institute discipline or a training and educational response to Michelle? Absolutely not. Even if you don't have enough evidence or, in consultation with your legal counsel, you're saying, yeah, these are offensive, maybe not necessarily rising to the level of hostile work environment. It's still really important for us to actualize an environment in which our employees are mutually respected. And this is not evidence of a level of mutual respect. And so that could be a warning. It could be maybe something more serious depending on Michelle's context, or it could be, and it should be training on these issues to be able to pick up if Michelle was unaware previously of the nature of that term articulate, to teach her about that issue.
And there are so many great resources now right on this subject, just like sexual harassment is really important to teach. DEI, microaggressions, implicit bias, things that everyone could use a refresher in those. I heard in one class, and it means the truth. If you're not uncomfortable with this conversation, you're not doing it right. That all of us should figure out where our sort of biases are and really be able to talk about them and learn from them. So having that type of awareness training amongst your staff in 2023, I think is really, really crucial.
Great. I just started to type in an answer on volunteers for if they have to be paid. I will say this, there's great information on the federal DOL website about this. They do try to make room for volunteers to be unpaid. It should not be your own employees who are volunteering on an unpaid basis. But there are fact sheets that the federal DOL has out there, and I believe they have one on volunteers. I would try to find that.
Great. This is important in co-ops too, because it's not unusual to have, say, employees volunteer to serve on a board committee or volunteer to participate in an annual meeting, and they're still co-op employees. So, which is a separate issue from just having members who want to come in and do some filing for you for 2 or 3 hours just as part of their participation in the co-op.
Right. Yes. If it's an employee, it's much more narrowly viewed as being not compensable. So in other words, you ordinarily, I would assume you have to pay them. Thank you, everyone. I know we've gone way over time. It's now 12:09. I really appreciate your patience. This has been a pleasure. Thank you, John, with your wisdom and insight. It's been a lot of fun. I hope everybody else found it useful. And have a good rest of your day.
Great. Thank you, everyone. And thank you, Tara. This has been so insightful for everybody.